So good afternoon, everyone. I'm delighted to welcome you at this webinar that the School of International Arbitration is organizing. It's one of our regular events that happen every month during the teaching terms. And I'm particularly delighted to be joined by two colleagues and friends who will be assisting us to debate what we described as an evergreen issue, that of confidentiality in international arbitration. And without further ado, I would like to introduce Anna Masser, who is the head of arbitration in Overy, Germany, and has experience not just working in Germany, but in various parts of the world, and cases which have a very broad range, and indeed one of the highest profile younger women in arbitration. So you could expect to be in the top 5, whatever, in the next. Give it a
Thank you. I take that as a compliment, Loukas.
Absolutely. I mean, you're certainly younger than I am, and then you have quite a bit to go. Speaking of evergreen, I would like to also introduce Larry Shore, somebody who's been a friend and a professor the past for the School of International Arbitration. He's now at Bonelli Erede in Milan, but he comes from the United States and has practiced there in England and in Italy, but also through that around the world. And some of you might have read, especially our students, I would hope, his excellent book on investment arbitration. Let me then set a bit the agenda for today. We are scheduled for about 90 minutes. We might just go a bit less. Understand that it might quite late for some time zones. We will encourage you to use the chat if you want to talk amongst each other. But should you have any questions, I would encourage you to use the Q&A session, and I see that the Q&A already is being used by somebody who has his birthday today, and we will then debate the issue with a number of questions. So it's a structured roundtable discussion, as I have described it. If you go to the questions, you can like a particular question that has been posed. And then, as we'll be taking questions later, we can take some of the questions which are either popular or intriguing. Then let me, and perhaps I should also alert you that the webinar is being recorded, but is not going to be released unless certain other conditions are being met as well. So let me set a bit of the parameter of the discussion. Increasingly, we read about arbitration in newspapers. Papers like the Financial Times, sometimes even the New York Times, and others would report about arbitration. The cases that they report are in most respects exceptional. I recall clearly the lengthy report of the Financial Times about the UCO's cases, the UCO shareholders' cases. And of course, from their perspective was that the amount of damages that has been awarded in that case was so significant. But the bigger question was whether this award will ever be enforced and how quick enforcement would be. There have been the reports in the New York Times a couple of years back were also exceptional. They were referring to different types of consumer arbitration or some sort of an arbitration which was imposed on parties. And again, none of these cases would qualify as a traditional, normal arbitration case as most people would experience, sort of a sales contract where something goes wrong, or an M&A where after the acquisition of a company, something is not exactly the way it has been promised. And then there's a bigger discussion there. So the Figaro, the French newspaper in September 2008, has written, amongst others, the custom is not to say who arbitrated what. And of course, the conclusion in that respect is that confidentiality is considered to be one of the crucial features of commercial arbitration. And the perceived wisdom, whether correctly or wrongly, is that arbitration proceedings and arbitral awards have been considered confidential and remain confidential unless there is a reason to disclose their content. But from that time, and of course that is something that is confirmed very clearly in a lot of the surveys that not only Queen Mary but other organizations have indicated. I mean, in Queen Mary surveys, we never have anything under 50% in favor of confidentiality or privacy of the arbitration process. In a very recent survey, Rochier, one of the very interesting Scandinavian firms that does an annual survey, have a similar, perhaps even higher than 50%, that parties do consider arbitration to be confidential. That seems to be what the word in the arbitral circles is, perhaps even the word in the street. But for the last 15 or 20 years, there's also a very sustained debate about the need for transparency. What German newspapers were writing in that case about private arbitration, which is conducted by arbitrators in their offices, which have sort of marble staircases and crystal chandeliers, and perhaps they were targeting somebody else because that's not the offices of arbitrators I have typically seen. Most of them are sort of offices with very little light or no light and functional working light. But they have taken this debate that arbitration decides important financial matters, and there's very little public insight in what's happening. And because transparency is a popular term, I mean, don't forget that even glasnost means transparency, and that has started the collapse of a union, Soviet Union. The debate is how does transparency reconciles with confidentiality, and whether trends in investment arbitration affect commercial arbitration, and in what respect. And again, some of this transparency sort of debate is particularly typical in investment cases, but also something that is embraced by institutions which they want to, arbitration institutions that have a particular interest not in transparency, but in disclosing information about their work and their arbitral appointments. We now see that a lot of the ICC tribunals are being disclosed, but not all. We know whether arbitrator has been appointed by one party or the other, but not much more. And of course, we have a lot of debate in the legal press. Global Arbitration Review has been existing now for 14, 15 years, and we've seen a lot every time that a request for arbitration is being filed, even a commercial case, we know something about this case, because I assume the lawyers for the case just do inform GAR. And we have arbitrator research tool, which is a commercial enterprise. I do not know how expensive it is because you have to request a particular code. We have arbitrator intelligence, which the proper price is publicized. If you're a member, reports are $4,000. If you're not, dollars, the reports are $20,000. And all of this sort of broader debate. So I would like then to start the discussion by asking our panelists whether they agree with the findings in a lot of the commercial arbitration surveys, particularly, that arbitration is confidential. And if that's so, why do you think is that confidentiality has taken so much of a critical part in our debate? And I would like to start with Anna on this point.
Thank you very much, Loukas, for setting the scene and giving me the floor. I think when you say, are you in agreement that arbitration is confidential? I think we kind of have to take a step back. We had a pre-discussion, and I told that story when I was there. When I started in arbitration, kind of in student days, it was always the three big advantages of arbitration that we heard back in the beginning of the 2000s was it's fast, it's cheap, and it's confidential. So no enforceability discussion, no, nothing else. So it was kind of hammered into our mind. It's fast, it's cheap, it's confidential. And when I started working in arbitration about 7-8 years later and moved to Switzerland, I think in one of my first cases, the question came up, can we actually, so there was an alleged breach of confidentiality in that arbitration. And the question came up, can we actually claim damages for that breach? And when looking into that issue in more detail, I, as a second-year lawyer, was totally flabbergasted that in Switzerland, an ICC arbitration is actually not confidential if you don't have an agreement. Because the ICC rules are silent on the issue, because the law doesn't say anything on it. So I think that the question of whether and to what extent confidentiality is, it's not always there. If you have it and if you agree on it, I think it is a valid advantage of, in particular, commercial arbitrations, because I do think that the main aim of arbitration is a service to the users. And if the users agree to keep their dispute confidential, I see no reason for commercial arbitrations, but for potentially in particular circumstances to which we may get later, that a confidentiality obligation on both parties, on the institution, on the witnesses, on whomever, and we're going to get to that in detail later too, I would propose that that is actually something that is good for arbitration and the users and the system.
Larry, what is your perspective?
Thanks, Loukas. And I wanted to say it's a pleasure to be with Loukas and Anna in this discussion, which I think is an important one, an interesting one. As Loukas said, Evergreen, which was nice of him also to say that I was not in the old person category and in the evergreen category. It's very kind, Loukas. I pretty much agree with what Anna said, particularly her point about service to users and commercial arbitration. I know we'll come to investment arbitration a little later, but parties, I think, by and large, or at least it looks like a significant percentage do expect. What I would say is not so much confidentiality, but they absolutely positively expect privacy. And it's often hard to distinguish the two, but I think it's pretty clear that when parties sign that arbitration agreement or sign a contract containing the arbitration agreement, they think that there's a hearing. Members of the public are not going to be permitted. There's not going to be a journalist. The CEO or the CFO is not going to be met before she or he goes into the hearing room on the steps of the building by a cameraman and have to comment about the case. And the hearing itself will be a private proceeding. Now, confidentiality is something else than that. And I agree with Anna that a lot of times parties also think that they're getting confidentiality. That is to say that apart from the hearing, that materials that are exchanged in the course of the proceedings, submissions that are made, won't see the light of day unless there may be a court application. But of course, we know in many jurisdictions that kind of protection really doesn't exist well before you get to a court hearing. On that, I do think there's some division between parties. For example, I do think that a lot of parties want to know a lot of things about their arbitrators, about opposing counsel, about the opposing party and what they've done. They want to know a lot of things that have happened in the institution. They just don't want anything to be known about their case. Everything else they want to know about, but not their case. That's what confidentiality means to them. And that's a harder sell. And I think many parties are surprised when they don't have that. But I do think that it's a fairly stable thing fairly stable preference for privacy, a very stable expectation of privacy, but confidentiality is different.
And I think that's a very good point, because that brings us back perhaps to historical English arbitration in the commodities area, for example, where awards of the LMAA or other sort of commodities exchanges would be sort of posted on the door of the Baltic Exchange. The award as such was not seen as confidential. What happened in the arbitration was entirely private, and that was not disclosed, and the awards were also quite limited, so they would not be as long as a lot of the awards we see these days. And of course, that's a consequence of opening up the debate. And it's interesting what the point you made about expectations, because and we'll come to the legal basis recently, but I've been in reading up again a bit before our session today. I came across to the Singapore arbitration reform bill, where they were very, very careful to say that the ministry particularly was particularly keen to say that we are not codifying confidentiality obligations, but we need to strengthen the ability of parties to enforce existing rights in arbitration. So they see sort of confidentiality as an existing right, but the point that Anna made, the enforcement of such rights was really up in the air, and Singapore is very keen to do that. And of course, we'll come perhaps to discuss a bit later the case of India and Vedanta in the Singaporean court, where so there was the request for cross-disclosure of documents which have been disclosed in one case to be disclosed in another. So, assuming then that and I think we are almost agreeing where we are in terms of confidentiality and privacy, and I see that you are arguing that arbitration is a service provided to the parties, it's not just an exercise of state authority like the courts would do. What is then, Larry, your reaction about all of this call for transparency? So how do you read these requests for transparency?
Well, as you indicated in the very beginning, Loukas, I think it's a mix of issues going or becoming public in the public space and the media coverage that specific cases get. I mean, in Germany, it's the Vattenfall case. In the world, it's the Loukas case. And it's all bad. It takes too long. It's too expensive. The investors always win. And I mean, that debate kind of got essentially started when businesses, it's like going back maybe a step. So usually investment arbitration and BITs, so bilateral investment treaties protecting that investment, they were to the benefit of northern companies investing in the southern parts of the globe. Yeah? So, and obviously German companies are very happy if they don't need to go to court in some African country, but can rely on that protection they have in a bilateral investment treaty or whatever else treaty. Yeah. Once, to the extent that kind of changed and the companies actually were going against the states, like Germany, like the US now has the first exit case against it, like other northern globe, I would call them, countries, that kind of gave rise to a debate in the public that wasn't there before. And that debate unhealthily led to all these critiques of TTIP, and then the EU said it's all bad and the system is bad and we need to change the system. And that essentially led to also, and I'm not saying it's all bad, but also the kind of heightened scrutiny and the requests for more transparency, particularly in the investment arbitration area. But if you look at Vattenfall, I mean, the hearings are streamed on YouTube. It's not going to get more transparent than that. Yeah? The award is going to be published. So in the end, that's not a transparency issue. Yeah? So I think what is lacking in the debate is kind of the distinguishing between the particularities and to distinguish between A, investment arbitration, commercial arbitration, and B, also distinguish between transparency and for what and to whom? I mean, there's the one thing you mentioned is you have the transparency of the institutions towards the parties, giving reasons for decisions. That is kind of a transparency, but also to the users. And then you have the other transparency where the institution actually published to the outside and where the addressee of the transparency is the public. And I think we need to distinguish between A, investment and commercial, and B, internal transparency to the parties and external transparency to the public. And depending on what issue you look at, you might come to different conclusions as to whether a transparency is actually merited or not.
Larry?
Yeah, I think there are a lot of cross currents, and I do think it's a very interesting point you raised, Loukas, that there was, for example, or there has been in the shipping and in the commodities industries a history of openness, at least in terms of, again, publication of awards as opposed to people attending hearings. And I think a lot of that had to do with trade usage within those industries. That is, those awards were actually very significant in developing understanding of trade usage in that industry. It was also important because the same arbitrators were getting appointed again and again, and indeed even in many jurisdictions today and under I think many sets of rules, there's less of a concern for repeat appointments in the shipping industry or in commodities, and it's all part of that, I think, trade usage idea. And then I think as commercial arbitration has gone, of course, well beyond that, I think the accountability and the concern that things are getting so big that only a few big players would have insight into what is going on in those cases in that broader international commercial arbitration space led a lot of people inside and outside what is commonly called the arbitration community to be concerned that only inside players have real knowledge and ability to make decisions based on frequent understanding of the arbitrators, frequent approaches taken by institutions. So the transparency, I think, ironically, came with greater importance and greater size in order to, one, make sure there was more accountability, but two, also to make sure that, I would say, big firms like Anna's did not have all the knowledge and were able to just have the understanding of who the players were. So I think, and that's the positive sense, I think, in which the transparency impulse came through. But I agree with Anna. There's a lot of the negative sense in terms of suspicion, which also may not have been warranted, but certainly was there.
Yes, and in that respect, I can bring already a couple of the points that have been happening in the Q&A and in the chat. Jeffrey Beresford-Hartwell makes the point: should there always be public transparency of private meetings? And for most purposes, an arbitration hearing is a private meeting, which is activated by an agreement of the parties. Would we have that? And of course, one would say naively that when we used to go out, where we were able to go out and sitting in cafes, very often you could overhear conversations of the people, but simply because they did not take any measures to protect the confidentiality or the privacy of their conversations, or indeed of their phone calls. I mean, I'm surprised how many times people walk in the street with a phone, speakerphone, where you not only hear them, but you hear what the other person tells to them. I mean, but if they don't take any measures, that's fine. But most arbitration hearings will happen within 4 walls or partition walls, whatever, and the public will not be invited. If you go to Fleet Street or to Maxwell Chambers or to Ixit Hearing Center in Paris, you would have something which does not necessarily identify the parties, but you know that there is this hearing and there's with a particular number and party A or party B and or claimant and respondent. So that certainly sort of matter has been addressed. And on the need to know, I mean, Miriam Golby asks whether, especially when it comes not to the access to the hearing, but to the access to the award, whether we should make a distinction as to matters which are academically, sort of, not academic, but would be relevant to future disputes, because they look about standards, they look about sort of application of the law, and there is genuinely something to take away rather than an assessment of the facts. And those which are very fact specific, then obviously that people should not know what particularly happened unless this has a legal impact. What do you think about that? I mean, perhaps we're jumping a bit on the publication of awards, but this, I think, an interesting point to be made here. Larry, what do you think?
I'm deferring to Anna on that.
I knew you would say that. I mean, for me personally, I think the publication of awards is one thing that, in a sanitized, pseudonymized version, why not? Yeah, I mean, if you cannot discern the parties, and if there's actually legal reasoning that would be important for other tribunals to take a look at, or for courts even, why wouldn't German courts look at decision by arbitrators just as a kind of going forward to the future, fast forward? Yeah, I mean, in particular on issues like the CSG, where the tribunals maybe even have broader case law than the German courts would have access to, or the post-M&A disputes that allegedly are only happening in arbitration. I think generally, and that is again a question of what is the purpose of the transparency, yeah? And for the publication of awards, at least in a way and manner that doesn't let other people know who the parties were, and potentially also other things that are highly sensitive and business secrets and whatever, but you can always take these out. I mean, it's not, and mainly what is of interest is an understanding of the facts, but not more, and then the legal reasoning that the tribunal applied. And I think that's possible without disclosing too much. And the benefit and the purpose of that transparency would be an evolvement of the law, and for the common law countries, some sort of setting of precedent, and kind of an evolution that I think is not so bad.
Yeah.
Larry?
Yeah, no, I largely agree. I think Anna makes good points. My concern often about the impulse to publish commercial arbitration awards, and I do think there's a difference here with treaty awards. But with commercial awards, you know, in many instances, and this is a distinction from, as I think Loukas mentioned, the commodities or shipping history. I mean, many cases, large cases in which we're involved, as counsel certainly, we're the majority of the tribunal, or at least the president of the tribunal, is not qualified in the law in which she or he is deciding on the merits. That's, of course, what one of the big concerns of Thomas was, and he received so much criticism for a couple of years ago when he said, well, arbitration is going to stultify the development of English commercial law. So many cases are going to arbitration, and indeed decided non-English lawyers. And although his concern, as he was certainly informed by many people, was exaggerated, many important cases still in development of English commercial law go to the English courts. It does seem to me that he had a point in terms of commercial arbitration awards being of, let's say, limited relevance in terms of development of the law, unless, of course, they were deciding the tribunal on for example, it's a CISG case. That's different. But if you are you are deciding under a national law in which you are not a lawyer of, it would be maybe of limited value, except an arbitrator's thinking. And that is, of course, what a lot of people do want to know through publication of awards. And I certainly agree that many of them being fact-specific aren't going to reveal a whole lot unless we're involved in the case to know how they were decided. But still, I think if you want to know something about someone's approach, then you will see some part of an award. I think it's of limited value.
And of course, one should say that the Yearbook of Commercial Arbitration, for nearly sort of 45 years now, since 1976, they do publish sanitized version of awards. I mean, that's an access that you could easily have. And I understand that one of the reasons why the yearbook started is because Julian Liu, when he was working on his thesis, he had collected a lot of awards which he gave to Peter Sanders at some stage, and that meant that the ICA had sort of quite a bit to contribute to the yearbook, and then eventually became a fiction. Of course, the ICC publishes certain extracts of the decisions on a particular topic in the bulletin. But I wanted to sort of also bring one question which I think we should not oversee at this stage, and that comes from Nico Kikebush, who asked whether it should be possible for the public to have certain access to proceedings if one of the parties involved is a public institution, for example, the German Ministry of Transport and Digital Infrastructure. And perhaps here I would step back and said, if you have a listed company in any part of the world, it's an obligation of the board to notify shareholders of a particular dispute that is happening, particularly because that affects the risk exposure of the company. And of course, when the award has been rendered either in favor or against that company, again, the shareholders will be told. And in that sense, sort of the idea of the public interest, if one's government is involved, is similar. I mean, I wouldn't argue that citizens are shareholders of the state, but in some ways they are. So would then the nature or the parties to the case warrant that sort of access to information or access to the public to even to the hearings? And we mentioned sort of public hearings before. Who would like to have a first go on that?
Oh, I think Anna.
I think that's one of the more difficult questions, huh? And again, I think it's a question: what's the purpose of the transparency? And if it might also depend on the contractual background to the dispute. Yeah, has the ministry acted in a commercial manner, and is the ministry acting as a commercial entity, contracting with somebody, and then going into commercial arbitration might be a different stance than if it's a governmental act they're performing. But I do agree, and I see the point that even for commercial arbitration, if and to the extent state entities, government, whether it's a ministry or whether it's an entity owned by the state, that actually might shift the commercial nature of the dispute in a sense that if and to the extent the state entity is held liable for something, then who pays? Yeah. So I think that's probably one of the most difficult questions to answer in this debate. And I haven't really, honestly, I haven't formed a view. Yeah? I think if and to the extent a thing is commercial, I think I'm absolutely that if parties agree on confidentiality, the thing is confidential. If in investment arbitration, the things are getting more and more in the public, I'm also fine with that. But that's kind of the in-between thing where I'm honestly, I haven't formed a view. I think there's arguments on both sides, and where that one falls might also depend on the tribunal actually who's acting, yeah. Because if and to the extent they order confidentiality for that, and there's at least going to be one party who's going to request confidentiality, it's a difficult question. I don't have an answer. Larry?
No, well, I completely agree with that. I think it is one of possible exceptions to confidentiality. I mean, certainly in English case laws, it developed also through, I think, Ally Shipping and Emmett and Wilson. The idea that you'd have an interest of justice for the parties exception was rather more prevalent for the courts in those instances have to decide. The possibility of a public interest exception, I agree with Anna, that would be, I think, I would have to say a very narrow exception and would really need to be tightly confined, because you could always find a public interest in a case, especially if it involves two large businesses. However, I think, as you mentioned in addressing this issue at the outset, Loukas, a lot of times that information, that public interest information, if it involves, for example, large companies, listed companies, comes through public filings eventually. And the award is not crucial in order to establish that. And certainly the exchanges between the parties are not crucial. And it's very hard for me to see a substantial public interest exception in the international commercial arbitration space. That would be, I think, a very difficult one to. Certainly, it'd be difficult to define. It would depend on the issue. I think it would be pretty limited. Otherwise, I do think it would make confidentiality largely pointless.
I have some provisional thoughts on that, which I will share. But before I do that, I will also because I'm delighted that the chat has been very active, and I would like to take 2 points from the chat. One by Stefan Wilske, who asked whether there's a distinction between public interest, genuine public interest, and public curiosity, or sort of almost gossip, I would say. And the other point I wanted to take is the point from, I think it might, Kovas Balint, who says that sometimes a lot of these issues are so technical that cannot be interpreted by the press or the journalists. If they pick up something, they pick up a headline, but the headline might not be consistent with what really happened in the arbitration. And publishing such raw materials gives a sense of transparency. However, it does not serve the purpose of transparency, which I think it should be better understood by the public. He's asked whether, particularly, for example, in investment arbitration, the best option is to do a press release. And perhaps I should say to that, for a second point of Kovacs Balin, that ICSID, when the parties do not give the consent to publish the award, they do publish a 2 or 3 page summary, which is very similar to this Court of Justice of the European Union summary. But what the public understands and what the public doesn't understand, I mean, when I'm thinking about transparency and why transparency can have the wrong effect, I think of 2 hearings which are not arbitration. One is the infamous O.J. Simpson trial, and the other is the equally infamous Oscar Pistorius trial. I mean, the O.J. Simpson, I was perhaps not. I mean, it was not accessible to me easily, but the Pistorius was, and I tried to attend the first days of the hearing, and I was very clear that for all purposes, not perhaps on the South African criminal law, which I'm not an expert, he killed his wife. I mean, he used the gun. This gun killed his wife, and you start sort of following the hearing, and then at the end there's an award, and there's a decision by the judge. And when you see the decision, something doesn't seem to be right. And I think the difficulty about public interest and access of the public to a hearing is how do you protect the integrity of the arbitration process, and how do you ensure that the arbitrators are not being influenced by public feelings, while the arbitrators historically have been able to work on the facts, the law, and the submission of the parties, and then they could be in that vacuum, which in that vacuum arguably they could issue a decision which is not influenced by any external factors. And of course, judges are trained to not be influenced by what happens in the hearing hall, not to shield themselves from what is in the press. But do arbitrators have the same floodgates or not?
So I can see Anna's going to go first on this. And I appreciate it. It's a question generated by Dr. Vilsky. I agree with your serious concern, Lucas, but I think that does really relate to a privacy issue. That is, it is a problem, I do think, if you're going to have people attending hearing. Reading a ward is different, or seeing materials or having access to materials generated during an arbitration, even if it's the transcript of the hearing. I think that's a very different thing. I still think that there would be many good reasons to say that that's still confidential, unless in the interest of justice for one of the parties is necessary for that information to become public. But again, it's pretty hard for me to see what the advantages are for the public, in particular in those instances in what is usually a business-to-business arbitral case, and hard for me to see the advantage to the parties and to the arbitrators and to the process. So I'd agree with your initial point that the process itself might suffer. I certainly think one aspect of the process would definitely suffer, and that's efficiency. Because I think the more scrutiny, the more you're going to want to make sure you are being seen, take every step in order to deliberate on an issue, as opposed to, as Anna said at the outset, keep in mind your service provider role. I mean, yeah, you have a giver of justice role. There's no doubt about that. And there's a tension often, but I think that the tension will become very great if the service provider is put in a position, in effect, where the taxpayer is scrutinizing as opposed to the parties.
Yeah, I think I agree, Larry. With regard to Stefan Wilske's comment, I think that you put it as a curiosity. You could also call it voyeurism. I think we all read Gar. Yeah, we all actually I like reading Gar. Yeah, I like the gossipy part of this, but I honestly see no public interest in these news. Yeah, I mean it's a kind of a tabloid for us to kind of see who's doing what and have a kind of an overview of what's happening, but I wouldn't put that equivalent to any sort of public interest in transparency. Having said that, I think that the scrutiny part, Larry, you mentioned, of having somebody kind of witness what you're doing, which would also kind of be scrutiny could also means that if you publish the award, for example, obviously, and you know who the arbitrators were, then you would have a scrutiny over the name, over the work of the arbitrators in that particular case. Yeah? At least the output. I don't know what happened before, but you would see the output. And I see some benefit in the sense that we all have seen awards that are just ridiculously badly reasoned. From renowned people in this area of the law. Yeah. So, and I think having some kind of scrutiny over that would actually potentially benefit. And I see your point that might kind of take longer, because obviously you draft more carefully if you know that your award will be published. But I mean, judges do that all the time. I mean, if this becomes the norm at some stage, and all awards are being published in some form or matter, not all, but kind of the rule is they're published and then there's exceptions. Yeah? I think at some stage you just have to get used to it, because otherwise you just don't deliver on your efficiency prerequisite. Yeah? And I think parties are willing to take that. It's not like, and then also, I think there's going to be a balance at some stage. I mean, there's regional court decisions in Germany which are very, very well reasoned. Nevertheless, they've been rendered within 6 months. That doesn't. It's been, yeah. I'm kind of a two hearts are in my mind to that effect. Yeah, I think there might be huge benefits, and I might even be willing to take the downside that it might take a month longer.
Yeah, I would like also to bring two more comments. One by Audrey Shepard, who asks whether advocates favor privacy because they don't like public criticism, very much like a la Bruce Castor yesterday, as he put it. But also I wanted to sort of...
Is that the one with the cat? I'm not a cat. I'm not a cat. Was that the one? Sorry, there was a video up on the Guardian this morning where there was one person in the virtual hearing as a cat.
This is Texas, but no, actually the Bruce Castor. Yeah, I think the Bruce Castor, it was in the Trump impeachment trial.
Yeah.
A bit more. I mean, the poor guy, maybe not poor actually, but the guy with the cat is obviously his children have used the Zoom before.
Yeah, it was actually his assistant. But I mean, it's like, and he's saying, "I'm not a cat," and then the judge says, "Yes, I can see that." Sorry, made my day. But
I would agree with Audley to a certain degree. That is, I mean, I'm always fearful. There may be a lot of fear involved, but I think it's fear enough if your client is there and the person paying you. So I think it's not that so much, but I think that probably Audley's got a point about still a comfort in a closed system. And the assurance that you're in amongst people who you may see on a repeat basis, and that everyone on that basis may be marginally more civil and polite. I'm not so sure about that working in our field right now, but certainly that might have been the case a couple of decades ago.
Okay, I would like then to take two actually rather briefer questions, and then the second one will take us back to discussing sort of the more backbone of confidentiality, and then we will take a number of issues, a number of questions in the chat related about the role of institutions and the evolution of institutions, very much also in a provocative sense, where institutions have taken too much of a role in transparency away from the parties. But the first point is from Shobana Iyer, who says that when public interest can arise in confidential commercial arbitration, when, for example, you have a determination about a patent, and of course, a determination of a tribunal or a patent where that is possible in countries like Switzerland or in the US, that will impact on other people because the patent validity is not just between the disputing parties, but will have a broader impact. Wouldn't that perhaps justify sort of some waiver of confidentiality? Any quick answer on that?
Well, a quick answer, if they're listed, they have to report, I think. So the question only comes up with non-listed companies. And then I honestly, I'm not a patent lawyer, but I would, maybe there's actually an obligation to disclose that on the party who lost the patent. But that's just a view.
Yeah, I agree with Anna. I mean, I I think, again, you can always find a reason for someone to have an interest, but defining that as a public interest, I think that's a much steeper hill to climb. And it would, again, I think if you believe in private dispute resolution, then you need to believe in private dispute resolution and to think that it's not the same as a national court where the taxpayer is paying for the decision maker and the courtroom, which is not the case in international commercial arbitration. And there may be many interested parties who are not party to the case, like employees of the companies, especially if they're large companies, and it may be of interest for them to know what's going on. But it seems to me then you're kind of ending private dispute resolution because they're opening it all up. And I don't think that is beneficial. I think that there is a public interest in private dispute resolution.
And one can argue that this is perhaps one of the reasons why so many jurisdictions would not allow the arbitrability of patents, because there's a genuine public interest and the patent office that awarded the patent has that public role, and therefore it could be served better there than arbitration. So, I mean, it would be, even in Switzerland and the US, would be rather unusual. You have a full-fledged validity, patent validity arbitration would be more a commercial matter. Now, the final point that before we go back to the discussion from the Q&A is from Francesco Bentivegna, and he wants to see whether there's a consensus amongst the panelists and the moderator on the principle that confidentiality and transparency are two distinct issues. While transparency is an essential element of the arbitral proceedings, the parties agree that such proceedings to be kept confidential to the outside world. Is there consensus about that?
You have to repeat that, Loukas.
Not sure.
It's great. Yeah, same here.
Yeah.
While transparency is an essential element of the arbitral proceedings, the parties may agree that such proceedings be kept confidential to the outside world.
I still don't understand the question. The question is whether the two are distinct or whether they actually, I mean, is the question that transparency can only exist to an extent where the parties haven't agreed on confidentiality?
If that's what is implied by Francesco, I would agree with that. But I would think that I would make a different point. I will argue that the actual proceedings are private. Now, the existence of the arbitration, perhaps the outcome of the arbitration might not be confidential, but I think the point that was made earlier in the first round of exchanges, I think by both of you, was that the actual proceedings are private, are in camera. They're not in the public sphere, unless you operate under a free trade agreement, which has a public hearing, and that's a different ballgame.
Yeah, I would agree with that.
Yes, I would say that I think I see where the question is going. There's certainly, it's difficult to say there's a complete curtain, an iron curtain, where you can say it's all going to be private and confidential. It's difficult because there would be exceptions that would be recognized even in strict confidentiality jurisdictions. And it not just relates to the scrutiny of the award in national court, which still could be done depending on the national court in camera, but it's difficult in many of those proceedings to keep it confidential. But you could also certainly say that the parties themselves in using, and I think this is where a lot of the court cases are generated, in using the materials that are submitted in the arbitration or exchanged in the arbitration, that somehow those materials are used in separate proceedings, other proceedings. And so in that sense, it would be difficult to absolutely draw the line. But I think many jurisdictions, England and Wales being one of them, is pretty good in drawing the line, and other jurisdictions have wavered, like Australia, which has amended its act a couple of times, and I believe is now an opt-out provision in the International Arbitration Act 20 years after SO, and I think there is a lot of, as I mentioned before, cross-currents along those lines. And so I don't think the debate by any means is over, and I take the point that transparency and confidentiality are not always loggerheads, but it's a matter of where you draw the boundaries, and it depends often on the issue.
Yeah, and I might also, if I can just very quickly add, I think the coming back to your earlier point, Loukas, what's the remedy? Yeah, even if you breach, you just how do you prove, substantiate damages based on that breach?
Yeah, I mean, Francesco clarified that his question is whether a proceeding can and must be transparent, but I wonder whether that means technically there's an element of accountability there, while the arbitration as such is strictly confidential. But I mean, I have to say that I'm fascinated by how interactive the session is, because there's a lot of movement in the chat and the Q&A, and I would like to take a number of questions from students, which there have been a couple of them, and I would like to just sort of bring to your attention. Jessica Splendorio says, in your experience, has there been an evolution in institutional rules to address the tension between confidentiality and transparency, as Ms. Marshall's reference to the ICC rules being silent on the issue in the past? But of course, perhaps the ICC still is nothing specific about confidentiality entirely to the parties, but the ICC taking certain steps to talk about transparency of ICC arbitration, appointment, challenge, etc.
I think there's 2 points to that. Yeah? I think at the ICC itself and at other institutions. So I think we have a competition between institutions, and I think in particular Hong Kong, Singapore, China, they're all much more focused on confidentiality, and all of them have particular rules in their standard rules that deal with confidentiality, and are much broad. The confidentiality obligations under those rules is much broader than in Europe, at least in my view. As regards the ICC, or the DIS in Germany has confidentiality obligations, but for example, in Switzerland, they also have confidentiality obligations under the rules. If you look at, in particular, at the ICC rules, they haven't, so they still have no obligation of confidentiality in their rules, and they have been updating their notes to the parties. The latest update was just made public and is in force as of, I think, January 1st this year. And they have a section actually now dealing with the transparency, and one transparency for the decision-making process, and maybe that was what was meant with the transparency of the process, that they set out which decisions they are willing and able to communicate to the parties if so requested. That's the one side of their transparency, and the other side is that they reinforce, so they publish the names of the arbitrators, the field where the dispute takes place, so area of law like engineering or energy or whatever, how the tribunal was nominated, and now most recent addition is the secretary to the tribunal, who will be published if not reasonable. I think there even needs to be reasons for an objection. No, I think not everything is public, so you can request that things are kept under seal, essentially. But I think that the evolution at the ICC is actually more kind of fostering the transparency of the process from the administrative perspective. So I think that's something that I would say the ICC has been doing over the years, is trying to put an emphasis on a transparent decision-making process within the ICC, and I think that's a good thing. To the parties, to the users, to the council working on these matters, I think that's good. But as regards confidentiality obligation, there has not been an update for the ICC, at least.
But I think they try to bring some transparencies through practices rather than I think that's an interesting aspect of that.
Yeah, but I agree with that. And the institutions, I think, have rightly understood in the past 10 to 15 years that from the perspective of many lawyers who might not be in Western Europe or the United States, that they were seen as inside communities, and that they needed to show what was going on to people who were not regularly inside those institutions. And I think it was less to expose decision-making of tribunals than as Anis to expose that the institutions are themselves being fair to all the players who come to them, and all players should have confidence that inside people are not being given preferential treatment. And so publishing as much as you can, I think, assists in that. I think that the institutions are right about that. I'm not sure that it creates greater accountability, but it surely creates greater confidence that you're getting
and predictability as well, no? Yeah, and predictability as well. Yeah.
Okay, then Kelly Ziza has perhaps a different question. I mean, Jessica was asking the context of institutions, but Kelly is asking, are ad hoc arbitrations equally impacted by the obligation of transparency or confidentiality, depending on where you stand? And how does impact on the growth of ad hoc arbitration? Or is ad hoc arbitration the safe haven for fully confidential cases?
Yeah, interesting. I was listening to the presentation of the Russia Dispute Resolution Index yesterday, and Steffen Pielblad, who's the Secretary General of the Danish Arbitration Institution, he actually made the point, and he might have a point, that if and to the extent the institutions get rid of their confidentiality obligations, that's going to give a rise in ad hoc arbitrations, and whether that would be the aim remains to be questioned. I think there's a point, because obviously people are freer to shape their processes in ad hoc arbitration. Not saying I would support ad hoc arbitrations over institutional. I'd always prefer to have an institution in the background rather than doing it ad hoc. But I think he has a point in that we can, the parties are freer in designing their processes, even freer.
And one final, Larry, anything on that?
I was just going to add, I think that's a good point on being free. I think one thing that the confidentiality debate indicates is that the idea that arbitration agreements should be as simple as possible, and this is one of the examples where maybe not, because if parties really do want something in the way of private dispute resolution that's as tight as possible, because there are so many countervailing currents in jurisdictions, national courts, a lot of openness in many sets of institutional rules, as we've discussed, that it really is one of those areas where it really needs to have comfort in the agreement. And that is not something, at least along the lines of what Anna mentioned right at the beginning, when you think of, just don't do anything too fancy in your arbitration clause, because you don't want to do anything more than what you need to do to protect jurisdiction. So, it's seat, number of arbitrators, clarity on scope of the dispute clause. One thing you want clarity about is confidentiality, and you really don't have it unless you put it in your agreement.
Yeah.
I mean, one final question of students, and we'll go back to the original questions. Kiro asked whether there's whether confidentiality is feasible when you can always breach it by way of challenging the award or having enforcement proceedings. And Brandon Malone and Shobana, I already replied to him that under Scottish law and under English practice, you could anonymize the awards. Perhaps I should mention here, typically, the City of Moscow and Bankers Trust case, where the English courts were very, very clear that when there's particular issues, if the award is confidential, the hearing is confidential. That's the end of the story. And of course, we've seen recently the case about the disclosure, non-disclosure arbitrators in a very well-known English case now, where arbitrator was always mentioned as Mr. M, but of course he wasn't Mr. M, was KR, and then that has not been disclosed until after the Supreme Court. We'll have sort of, I think as the time advances, we've been on for more than an hour and 10 minutes. And we had originally, I should inform the audience, 14 questions with sub-questions to go through, and we are only through question 1, and of course we picked up a few on the way. So I will be a bit selective. Assuming that as service providers, we take that confidentiality still has some validity. What do you think is the real legal basis? Is the agreement of the parties the law, or is custom a safe haven for the legal basis of confidentiality?
Anna's looking at me. Certainly we know it's implied of the under English law for the arbitration agreement, implied as a matter of law, as a function of the arbitration agreement. But the legal basis, I think that is, we know what it is in England and Wales, and we know it varies in other jurisdictions. I would say the legal basis in jurisdictions where it doesn't exist is pretty interesting for the lack of discussion. So for example, for the United States cites United States versus Panhandle, which I think is 1988, United States District Court, Delaware. And what's so interesting is when you, but this is a memory, when you actually read that case, there's no reasoning at all about lack of confidentiality. All it is the court looking at an affidavit that was produced by a very famous Debevoise lawyer at the time and novelist, Louis Begley, who produced an affidavit so that the client in that case could keep information disclosed in a case, disclosed in arbitration, private, and looked at the ICC rules at the time, which are, in this instance, as Anna said, not so much different. And the court analyzed the affidavit, looked at the ICC rules, and said, but this is all internal to the ICC. It has nothing to do with the arbitral process itself, so I'm denying the protective order and the information come out. That's the basis for many U.S. court decisions to say there's no confidentiality in arbitration in the United States. There's no reasoning at all on that basis. It was just on the basis of one affidavit in the ICC rules. And I think so the legal basis for lack of confidentiality, in the same way maybe in 1995 in Australia, when you begin to look at it, I look at it from that side, it's really quite questionable. And so that's why I think some jurisdictions like Australia make a change, and some, like the United States, put a much greater emphasis than on privacy. And what's the legal basis, though, if you don't have an agreement between the parties? Well, you're looking at a connection between privacy and confidentiality. That is to say, privacy doesn't make a whole lot of sense if you can publish the transcript of the hearing. That would be the legal, maybe one of the legal reasoning bases. But I think, again, it's hard to draw that boundary.
Yeah, and it depends on the legal system you are working under. No, I mean, there's jurisdictions that have express confidentiality obligations in their arbitration acts. There's jurisdictions, and I noted that down. I hope I'm right. New Zealand, Spain, Scotland, and then you have a jurisdiction where a duty is implied, like the UK, and then you have jurisdictions where you have no express, no implied. And then you have a fourth, which actually have counter. So they say it's not confidential, but for you agree, for example, in Norway. So I think it depends on the legal system you're looking at. And if and to the extent you as party want to ensure that you have confidentiality, you have to conclude an agreement. Because you are never certain where that dispute is going to end up, in particular in international settings where you want to enforce, and that's a different question. I mean, if you need enforcement, confidentiality actually potentially makes enforcement easier, because if and to the extent you lose, at least if you pay, it doesn't get public. If you manage to keep it confidential until the award. So I think that might also be another benefit for confidentiality. But to answer the question, it depends. And if you want to have some kind of certainty, you better conclude a party agreement or refer to rules that entail a confidentiality obligation.
So if one wants confidentiality, the best way is to either agree specifically, or is that is somehow incorporated in the procedural order number 1 or any procedural order the tribunal would make, but not perhaps with the agreement of the parties. And I think we agree that the arbitrators and tribunal secretaries have a duty of confidentiality. Does it apply to parties and their lawyers? Or they are free to do?
So they're depending, well, that's the issue, because of course the institutions, their hands are tied, arbitrators, their hands are tied, and that's all pretty clear. It's all down to the parties, and that's all down to jurisdiction generally, and what you're looking at in terms of seat, and that precisely because there is so much, I think. So much presumption that may be a false presumption. That's the central issue about whether you use the materials in the arbitration. And I think their parties do want it both ways, in the same way that they want it both ways to be able to understand when people maybe in their same industry or have a dispute resolved. They want to see if that award goes to court. They don't want the court to be doing things on a anonymized basis. They want to see it. But if they're going to court, especially if they've lost, then it's a different issue. But it's all about the parties, the arbitrators and the institutions. I don't think there's any issue. You can't do anything. But the parties, there's a lot of flexibility depending on the jurisdiction.
And I think the last point I wanted to particularly address on the commercial arbitration arena is that it seems the difficulty here is that once the confidentiality has been breached, how you effectively protect yourself unless you can prove damages. The point that I was making as a younger associate in Switzerland.
Yeah. Yeah, I mean, what's the remedy? You know, we had that issue earlier. What's the remedy of a breach, and where do you enforce that? Is that actually under the jurisdiction of the tribunal if you don't have an obligation? Well, if you do have an obligation, does that obligation, and then if breached, give the tribunal competence to rule on the dispute whether and to what extent the confidentiality has been breached and award damages in that same arbitration? I would tend to say yes. but it might depend on the circumstances too. Yeah.
And we saw that in the revision of the law in Singapore, they want to try to possibly make the breach of confidentiality obligations action, or the ability to enforce that. How that will work in practice remains to be seen, but the Vedanta in India, Vedanta was one of the cases which has been fully debated there in court. Then I think in the interest of time, we have only about 12 minutes. I would like to address two issues. One is the question that was raised by Patricia Shaughnessy. It was this particularly to Anna, but I'm sure Larry can give an out answer as well. Playing devil's advocate, the ability to access, harvest, and use information has a monetary and a non-monetary value. Why should arbitral institutions be able to have this ability as a default position, subject to the party's objection? Is it in the public interest for this information to be used and even made available on their databases, which often require subscription?
And expensive subscriptions.
I think that's the first part of Patricia's question. Say again, Loukas, please.
So playing the devil's advocate, the ability to access, yes, harvest, and use information has a monetary and a non-monetary value. Why should institutions should be able to have this ability as a default position of collecting the data and make it available in their databases, but which the parties may not be able to access without paying?
Should the ICC pay for the consent to publish?
Yeah, I'm not touching that. I don't know. I would say this. It's interesting because there's legislation right now that's stuck in the House of Representatives in the U.S., the 21st Century Courts Act, to make PACER free. Right now, PACER is in order to get court documents pay, and it is a transparency issue, and the legislation right now is to make that free. The question is who's paying for that in that context. That'll be, we know, in the institutional context. I think you could say broadly, I'd be interested in Patricia's view on this, but you could say broadly that's part of what the parties are paying for to support the arbitral institution, and that it is part of the arbitral process to make it safer for everyone, because the data is going to be available to potentially repeat users, not just a party who's using it once.
Can I argue against that? Sorry, just because I think I think Patricia does have. Whose award is it actually? And the ICC was charging before, and now they're publishing in addition on top. They don't pay for that. And again, whose award is it? I would say it's the parties primarily. And then the second question is, again, what's the transparency for? What's the purpose for the transparency? And if the purpose for the transparency is actually access publicly, then the question does come up: why do we have to pay registration fees for the library to access? Yeah, I think, and then kind of a few elite law firms have it, or elite lawyers have it, but not the public. And the question is, does that serve the purpose we're trying to serve by publishing in full? Just again, playing devil's advocate. I like your question.
No, I take the point. I think it may be, you enter into private dispute resolution with an institution. That's part of what going in, and it may be an ad hoc thing. But I think it's one of those accountability measures that I take the point. It's hard to say why you're giving up that when the institution is not paying for it, unless you know that going in, you are paying for it.
I don't want you to answer this question because I know it's beyond what we have said we're going to discuss in our preliminary sessions. But I wonder whether under GDPR rules, arbitrators have an automatic free access, or even lawyers to IC processes have an automatic access to these databases because they contain data. But I don't want you to answer this question because we said we are not going to discuss GDPR. But in the remaining 7 minutes, I want you to move to a slightly different direction. I think we accept that as counsel arbitrators, service providers, we do not disclose information that people should not have. If the counsel wants to disclose information, that's a different question. But we have two elements which come up quite a bit in the Q&A and have also come in the chat. And one is, more towards investment arbitration or arbitration with the public interest. So we have now NGOs who want to have some access as non-disputing parties if there is a particular public interest in the matter. We have ESG issues that go more to arbitration, and therefore logically there is some sort of a broader interest in knowing what happens there in terms of social responsibility and so on. So if that is the case, why then the main action that the states have taken in respect of transparency, namely the Mauritius Convention, does not seem to have taken that much support by way of ratifications? So is transparency important for journalists and NGOs but not for states?
It's a difficult question. I think it also depends on the player you're looking at. I think for the EU, they're just trying to stay away from investor-state arbitration as far as possible. So ratifying that convention would actually not currently, in the current circumstances, not really be sensible for them because they want to get out. They want to do their own thing, and are trying to get out of the not only the bilateral investment treaties, but I think also the ECT is kind of up there for, at least for intra-EU disputes, that is going to be a debate that's forthcoming. So I think that would be counterproductive for their view of things to sign up, at least for Europe. And for other parts of the world, I think it's just, I don't have an explanation.
Certainly, nor do I. The last time I checked, Mauritius is only about 3 ratifying states. Is that right? And maybe for 20 that have signed.
It's now 7. It will
7.
Australia, Bolivia, Cameroon, Canada, Gambia, Mauritius, and Switzerland.
And not involving a whole lot of BITs, and more signatory countries, maybe now close to 30, but with few ratifications coming quickly. I do think it is part of the cross current that is there may be an impulse in certain respects in treaty arbitration, certainly transparency in terms of awards. They may have more value in development of international investment law, but in terms of the process, that's still something that a privacy concern. I think for many states would still want to have control of that treaty by treaty, as opposed to a blanket treaty that would leave all sorts of discretion out for the state and just simply say, well, this transparency rule applies to all of your treaties. And I think there is a reasonable and rational concern on the part of many states to not sign up to something that is any sort of blanket commitment.
And I think what comes perhaps to the final point that we can address, as an academic, I can see why it is important to have publication of awards, or at least the legal reasoning of the awards. It's something that younger generations of arbitration lawyers can access. If you have a full sort of publication of awards, you can even see how arguments are being considered by tribunals one way or another. So there's a general academic interest, and I think, for example, in countries like China, CITAC has a 5-year moratorium on awards. But of course, CITAC awards are also very short. But after 5 years, most CITAC awards are being published in one form or the other. So I wonder whether what remains on the public, I mean, not the public interest, but the specific public interest of lawyers, younger lawyers, people who aspire to work in arbitration, how we distinguish how much of that is genuine interest and how much of that is what Stefan Wilske earlier called as curiosity. And we thought, for example, that GAR might be some sort of a tabloid, but now we have arbitrator intelligence, we have Jus Mundi, we have IA Reporter, we have the GAR arbitration research tool. So we have a lot of focus on arbitrators and how they're being appointed, by whom they're being appointed, how busy they are. And some of that is actually very legitimate public information. Some of them advertise it anyway. But some of them do not. Do we think that all of this new data collection is with free access or not? I mean, that's another problem. But it's there to stay, but is it a good development or not?
It's not going to go away. So I think whether it's good or bad, it's there. Yeah. And it's not going to go away. What I think is really, and I'm using it so I can, and it's not a publication here, but what I really find helpful is Jus Mundi, because I think they kind of collate the information in a way that is helpful to our work, and makes it more accessible. And essentially, at least that's my impression, they collate publicly available data and cluster it in a manner that it actually makes sense to read. Yeah, so I don't have to look in 5,000 different places for the information, so they kind of collate what's there. I think that's very, very helpful. For arbitrator research tools, I don't really have a view. I think A&O has a view. I think we don't participate, at least not in the GAR thing. I believe might also be a personal partner's decision, but my impression is we don't. At least I don't. I can say that for myself. But I do believe, and I think there's but we do have a subscription. We probably would look before we appoint who's sitting with whom, and kind of, and that is also something that I don't think is unhelpful. I would say it, yeah, and that information is not only available to particular few who actually have the benefit of having more insights than others. I think it's just leveling the playing field. So I think in the end, I'd be cautiously saying it's a good thing. Cautiously.
Larry?
So I'm not going to say that more information is bad. I would say generally, you would want there to be more, and it can be helpful. It's new in the arbitration world. It's of course not new in many jurisdictions with evaluations of judges. I mean, if you look at the roving room in the United States to see information about judges, it's pretty unhelpful. I mean, you read it anyway, but it doesn't tell you very much. I think that might be often the case with some of the new information. There may be something of use in there. The one thing I would say is the laudable goal of leveling the playing field, I don't think it's really much achieved by that, because I think ultimately you want to get a different level of information. If you're, for example, appearing before someone or thinking of appearing before someone for the first time, it's something, but I think it's more to be doing what many, virtually everyone who's into this seminar or webinar tonight is doing, is trading information between colleagues, and it's a much less formal, but I think much more valuable exchange.
I think the German will say that all this amount of new information is mit Vorsicht zu genießen. So, it doesn't really translate as you should take it with a grain of salt. It's not exactly the same thing. But effectively, the question is that word of mouth still seems to be one of the most important sources of decision-making information in arbitration world. I mean, I get, not every week, but I get emails from former students, from friends. Do you know this person? Have you ever sat with him? What do you think about her? What's her reputation, or what's his reputation? So I think it will take perhaps a generation or 2 generations of development of AI and perhaps even sort of algorithms before we can get to data collection, which will be very reliable. And isn't enough in some of these data collections, I looked at who are the people who endorse that particular data collection, and I saw whether these people have their reports about them. They're not. They haven't provided any information. You know that these people say it's a wonderful database, level playing field, but want to try information about them specifically, and there's nothing there. So I think we can agree at the end of having exceeded our time that we could go on for much longer. I think there have been some 35 questions in the QA and the chat, which is in the context of the seminar, a very, very good number. We have not been able to answer all of them, and we disappointed some of you, but by not picking your questions. But we'll certainly, I mean, there was a very good question as to whether online arbitrations pose extra confidentiality and transparency issues. That's a very, very good question. And the question was about how do you develop the judiciary, which is also a broader perspective, as well as developing arbitration and the reason of transparency. But there's always limited in the amount of time we have, and the final comment that there's if there's an attempt to of an unhealthy public discussion about transparency become a driver in drafting rules for confidentiality, which will go to a different direction. So, but all of these are open questions, and all I can say is I would like to thank the audience for their very active participation, and I would like to thank our 2 panelists, Larry Shore and Anna Marshall and Larry Shore, for engaging with my questions and the audience questions so effectively. So I would like to propose a vote of thanks. And when we are allowed, I promise that I will buy you a drink of your choice.
I promise I'll come.
By all means.
Thank you, Loukas. Thanks, Anna. And thanks, everyone, for, as Loukas said, the probing questions. Thank you very much.
Thank you. Thank you.
Yes, thank you.
Have a very good evening, everyone.